here on behalf of Acting Mayor Joe DiPaolo. And I don't know if you want it on the recording or prior to that, Stephen.
No, that's quite all right. We'll just capture that in a minute as a staff person. Thanks.
Okay, he regrets that he can't be here tonight, but he really does honor the Heritage Committee in a big way.
Good. Well, thank you, Gord. Madam Chair, members of the committee, it appears that this meeting is now being live streamed. So I'll turn it over to you, Madam Chair.
Okay, thank you. So welcome everyone to this October 12th, 2001 Heritage Richmond Hill meeting. Tonight's meeting is an electronic meeting being held pursuant to section 238 3.3 of the Municipal Act of 2001. Due to efforts to contain the spread of COVID-19 and to protect all individuals, city facilities will not be open to the public to attend meetings until further notice. Please note that we have not received any regrets for tonight, but we are missing Dan Kelly and James, so hopefully they'll pop in very soon. The public had the opportunity to submit written correspondence regarding agenda matters by email to the clerk's office. All written correspondence received by noon today would have been included on the agenda, but there was none received. The public also had the opportunity to appear as electronic delegations, either by video conferencing or by telephone. By noon today, there were no delegation requests received. As the chair of the committee, I now call the meeting to order, and we will proceed to the first item of business on the agenda, the adoption agenda. But I wanted first to give a welcome to Tom. So thank you. This is your first time that you've been able to come. You were invited like the day before the meeting last time. So very understandably, you weren't here, but we're glad you're here now. And you are with, what's your position with the York Region Catholic School Board?
I'm the coordinating manager of planning and operations with York Catholic Board.
Okay, very good. So again, welcome.
Thank you very much.
So this is only the second time I've chaired the meeting. I'm a little rusty with Robert Rules of Order. Lena tried to give me a tutorial this afternoon, so we'll see how well I have learned everything. Okay, first, adoption of the meeting, adoption of the agenda. We are going to pull one item on the agenda, and that is the issue with a proposed schedule for many meetings for this committee. Talking with Stephen before the meeting, there are issues with it, so he's advised it's best to wait till next month to put forth a good schedule. So with that amendment, can I have someone to move the adoption of the agenda? Doris, thank you. All those in favor? Any opposed? No, very good. Okay, so the agenda is passed. Does any member need to disclose any pecuniary interest? And if so, to please state the general nature thereof. Okay, seeing none. And I assume that those who are on, I can't see that there's no issues. So, good. Okay, minutes of the previous meeting. There's 3.1 extract from the council meeting. C number 3521 held September 15th, 2021. As you can read from the agenda, the extract from the council meeting regarding staff report, there was a delegation of authority for summer recess accounting, which included approval of the staff report 21082, the heritage permit application for 103 Richmond Street, the Eliza Gabby House. And it was received. So just to note, that was something that was brought forth. Stephen, we do not need to do anything else with that, correct?
That's correct, Madam Chair. This is just to be received. That matter's already been fully dealt with.
Okay, thank you. Okay, now moving on to the minutes for the Heritage Richmond Hill meeting, September 14th, 2021. Is there a mover for the minutes?
Sure. I apologize, Madam Chair. You do need to move her for the extract, though, just to receive.
Okay,
yes,
sorry.
Apologize. Yep.
Okay, so I think I saw David being mover. All those in favor? Any opposed? No. Okay, that's carried. Okay, now to 3.2, last month's meeting minutes. Is there a mover for the minutes? Jenica, okay. Any discussion with the minutes? Okay, all those in favor? Any opposed? Okay, adoption of last month's meetings minutes are carried. Okay. Item 4 on the agenda is delegations. There are none. Okay. Scheduled business. Section 5.1. Heritage permit application for 1015 and 10157 Young Street, the Houston Skeel House and Shop. File D12-07458. So it says that the heritage application is to modify the storefront facade of 10115 and 10157 Young Street as described in Appendix A. So are there any, can we first have this moved? Okay, Doris. Okay, and any discussion? It was an interest. I found it an interesting report, and hopefully we have some discussion here. David.
Thank you, Madam Chair. I'm personally, as a councillor on, well, not that side of Young Street, but the other side of Young Street, I'm really pleased to see this. From what I understand in the staff report, this is an application for a community improvement grant that council implemented a few years ago to encourage restoration of some of the properties in that in the historic village area. And, you know, with this complete and a few on the Ward 4 side, on my side, complete and or coming up from what I understand, we're starting to really gather some momentum. And, you know, there's over the last couple of years, there's been several properties that the owners have invested in upgrading the facades and making them look nicer. And that's exactly what the program is for. It's exactly what I think we need to see for that area. You know, with the upgrade of the facade, hopefully we're going to see some really interesting businesses, you know, move in there and create a good vibrancy. And every time that happens, it creates a better environment for other businesses in that area to thrive. So if I could put two hands up when we vote, I'm not enthusiastic about it. I suspect, I don't want to put words in Councillor Silivet's mouth because that's not hygienic during a pandemic, but I suspect that she might do the same. So
okay.
Anyway, those would be my comments.
Okay. Karen, do you want to say something after that?
I 100% agree. Thank you, Madam Chair. 100% agree with Councillor West, including on the COVID-19 precautions. I'm very pleased to see this, and I think that we're most definitely moving in the right direction here. So it's fully supported. Thank you, Madam Chair.
Okay. Any other comments? Barb, I think I saw your hand up there. You're looking at the report.
I like everything that's happening. I can't really add more to what David already said.
Okay. Doris.
I have a question. I'm fully supportive of the permit being approved and moving forward with the changes to the facade. But when I went to look at the property and when I looked at the permit, I think what they're doing is great, much needed. But I was interested in knowing if there's any work planned for the other sides of the building, or if it's just the facade that they're working on now. And what are the implications for the other sides of the building, if there are any, with this proposal?
Okay. Okay.
Yeah, through you, Madam Chair. To my knowledge, I don't believe that there is anything on the other side. It is strictly for the front because the community improvement plan, it's dealing with the facade that the public deals with. So that would be along Young Street. So to my understanding, the work is limited to that facade that's fronting onto Young Street.
Okay. Okay. Is that fine response, Doris? Okay. Any other comments, questions? Okay. I had one. In reading it over, I noted that it was aluminum siding, and I thought that's not very heritage, Is there an explanation for that? Is that just standard, or can you comment on that?
Yes, when it comes to exterior cladding material, if they're not trying to recreate something, or if they're modifying sections of the building that aren't that have already been altered, we're okay with having them use materials that aren't necessarily heritage, such as aluminum siding. And in this situation, we thought that it was fitting that that facade has been severely altered over the years, and that the overall look is still in keeping with the heritage attributes of the building. So we thought that aluminum siding would be okay to use.
Okay, thank you for that response. So, okay, any other comments before we verify this? Okay, so all in favor? Okay, any opposed? Okay, motion carried. So that's 5.1. Okay, we now move to 5.2. We've taken off the agenda, which is the schedule of the heritage meeting schedule. 5.3 is a subcommittee verbal update. Is there anything to report? Is there an update?
Madam Chair, at
Yes.
this time, the designation subcommittee has no update to provide to you.
Okay, thank you very much, Doris. Okay. 5.4, the highlight of the meeting, a presentation by Pamela. So Pamela, we're looking forward to hearing what you have to say.
Yeah, some exciting changes to the Ontario Heritage Act. So I hope that I summarize them well, and I'll be taking questions afterwards in case something isn't clear. I know that it's going to be a lot to take in. All right, so as I said, a number of changes to the Ontario Heritage Act have come into effect this summer. So to assist HRH in understanding what these changes entail, staff have created a presentation outlining these changes and how they compare to the old Act policies. Next slide, please. So we will first provide a summary of what triggered the changes to the Act, as well as the steps that have been taken to date. Next, we will provide an overview of the legislative changes, and we'll introduce the new provincial regulations associated with the Act and Regulation 385-21, which has also been recently enacted. Finally, we will explain how these changes may impact HRH. Next slide. In 2019, the provincial government passed Bill 108, which was known as the More Homes, More Choices Act. In addition to changing the Ontario Heritage Act, it also made changes to the Conservation Authorities Act, the Planning Act, and the Environmental Protection Act, among others. Heritage staff made a presentation to HRA at the July 2019 meeting summarizing these changes. And while the new policies were originally planned to be enacted later that same year, public consultation was delayed due to the pandemic, so they did not come into effect until earlier this year on July 1st. Next slide. To assist those involved in heritage processes, the ministry has 5 documents that explain, in plain language, how to understand and use provincial heritage legislation. These 5 documents are called the Ontario Heritage Toolkit, and the 5 volumes cover, respectively, the designation of heritage properties, heritage conservation districts, heritage property evaluation, municipal heritage advisory committees, and places of worship. These will all be updated to reflect the legislative and regulatory requirements through the new Act. And while the Ontario Heritage Toolkit was previously available both in hard and digital copies, they will now only be available online. Next slide, please. Regulation 385-21 was established to support the implementation of the changes to the Act. While the Act outlines the policies, the regulation outlines specific details on how these policies shall be carried out. It includes situations that trigger a 90-day timeline for designation properties and exceptions to this rule, the steps needed to amend a designating bylaw, the rules for reapplying to repeal a designation bylaw, information to be included in alteration and demolition application, and the list of documents that must be submitted to the Ontario Land Tribunal when an appeal is received, among others. And next slide. We're now going to look at each process affected by the changes to the Act in more detail, starting with the process of listing properties on the register as non-designated properties. These changes to the listing process were the reason for the designation subcommittee suggestions on how the listing process may be improved, which we discussed at last month's HRH meeting. One of the new changes is that council is now required to notify the owner in writing within 30 days of listing a property on the register. This notice is only needed to be given to properties that are listed on or after the new act came into effect on June 30th. This notification must include certain information, including a statement explaining why the property is believed to have cultural heritage value or interest, a description to properly identify the property, such as by including the municipal address or a legal description, a statement telling the owner that they may object to the listing, and an explanation of the demolition restriction on any buildings on the property. Prior to these changes, the city was not required to give owners notice that their property had been listed. However, it was still Richmond Hill's practice to notify owners when their property was to be discussed at an HRH meeting, as well as when council made a decision on their property's heritage status. Council was also able to list a property without providing a reason for why they believed it to be a potential cultural heritage value or interest. And no statement on the property's potential cultural heritage value or interest was required for listed properties. Next slide. Continuing on with the changes to the listing process, owners may now object to their properties being added to the register, and there is no time limit on when they may do so. However, only the owners of properties listed after June 30th, 2021 are able to object to their property being listed. Prior to this, property owners could request that their property be removed from the register, but there was no formal process to do so under the Act. Next slide, please. Moving on to part 4, or individual designations, there was a number of changes to the designation process. For one, there is now a 90-day timeline to issue a notice of intention to designate should an application under the Planning Act be applied to the property. This time restriction is removed if the planning application for the property is disposed of under the Planning Act. The timeline may also be extended if both the owner and council either agree to extend the timeline or agree that the timeline will not apply, or if the municipality declares an emergency under the Emergency Management and Civil Protection Act. Under the old policies, there was no time restrictions with issuing a notice of intention to designate, and applications filed under the Planning Act did not impact processes under the Ontario Heritage Act. Next slide, please. A new step to the designation process was also introduced under the new Act policies. Property owners now have the ability to object directly to council within 30 days of the notice of intention to designate being published. At the end of this 30-day period, council will consider the objections that have been received and then decide to either withdraw the notice of intention to designate or proceed with passing the designation bylaw. The property owner still has the ability to appeal the designation once council passes the designation bylaw, and this appeal is brought to the Ontario Land Tribunal. Under the old policies, property owners could delegate council to voice their disagreement with the designation, but there was no formal process through which owners could object directly to council. While there was an appeal process under the old policies, these appeals were brought to the Conservation Review Board, and their decision was non-binding. Ultimately, council still had the final decision on designation. Next slide, please. All right, so we'll move next to the process for passing the designation bylaw. Like the notice of intention to designate, there's now a timeline for when the bylaw can be passed. The city must now pass a designation bylaw within 120 days of publishing the notice of intention to designate, or else the notice of intention is considered withdrawn and the city must issue a notice of withdrawal. This applies to new designations, repealing bylaws, and administrative amendments to bylaws. Like with a notice of intention to designate, the timeline for passing a bylaw can be extended if the owner and council agree to the extension. And if any part of the 120-day period falls during a declared emergency under the Emergency Management and Civil Protection Act, the 120-day period begins after the day on which the emergency is terminated. The timeline can also be amended if council passes a resolution stating that they have received new and relevant information that may affect the potential cultural heritage value or interest or heritage attributes of the property. In this case, the city will have 180 days from the date of the resolution to pass the bylaw. Under the old policies, there were no time limits on when a bylaw could be passed. Should a notice of intention be withdrawn, there's no time limit on when a city may issue another notice of intention to designate. Timelines have also been placed for owners requesting that their property be de-designated, with at least 1 year needing to have passed before they reapply for a de-designation. Under the old policies, there is no limitation on how often a property owner could request that their property be de-designated. Next slide, please. The new policies also set out the information that must be included in designation bylaws and is regulated through Ontario Regulation 385-21. This includes information on the property's location and its cultural heritage value or interest, and may also include a list of any physical features that are not heritage attributes and therefore would not require council approval for alteration. Any existing designation bylaws that needs amending must now also be amended to meet these new mandatory standards. Under the old policies, the only information that was mandated through the Act to be included in designation bylaws was a statement of cultural heritage value or interest and a description of the heritage attributes of the property. Next slide, please. Ontario Regulation 385-21 outlines the process for undertaking substantive amendments to a designation bylaw. While it's still similar to the process for a new designation, there are some notable exceptions, including no limitation to when a municipality can propose an amendment to a designation bylaw. The timeline is also different, with the municipality having 365 days from the publishing of the notice to amend to pass the amending bylaw. And this timeline can only be extended by mutual agreement between the owner and the city. Under the old policies, there were no timeline limitations for when an amending bylaw must be passed. Next slide, please. Now, a significant change that has been implemented through the new policies is that the removal of heritage attributes is now considered demolition rather than alteration. Under the old policies, only the removal of an entire structure was considered demolition. The new policies have also introduced mandatory steps that the city must take after they consent to the demolition or removal of a building, structure, or heritage attribute. Once the demolition is complete, council must determine what the demolition's impact is on the property's cultural heritage value or interest, and either do nothing, amend the designation bylaw, or repeal the designation bylaw. There is an abbreviated process should an amendment or repeal be required, which requires fewer notifications and no opportunity for objections or appeals. Under the old policies, there were no steps required to be taken after consent was given for a demolition. Next slide, please. Under the new policies, Ontario Regulation 385-21 sets out the minimum requirements for a complete application to alter or demolish a heritage attribute or structure. If council requires additional documents, these must be outlined through a municipal bylaw, council resolution, or official plan policy. Prior to the changes to the Act, it was up to each municipality to determine the requirements needed for a complete application. The city now has 60 days to confirm that an owner's application for an alteration or demolition is complete. Prior to the changes to the Act, there were no timelines for when a municipality was required to confirm the completeness of an application. In situations where a structure is moved to a new property, there is now a streamlined designation process that can be followed, which does not provide an opportunity to appeal the new designation. And a quick note that even though similar changes to alterations and demolition have been proposed for Part 5 designated properties, aka heritage conservation districts, they have not yet been proclaimed. Next slide, please. All appeals to municipal heritage decisions are now heard by the Ontario Land Tribunal, OLT. This includes all designation decisions, such as new designations, proposals to amend a designation bylaw, and applications to repeal a designation bylaw, and decisions on an application to alter an individually or Part 4 designated property. The OLT's decisions are binding. Under the old Act, most of these decisions were brought to the Conservation Review Board, whose recommendations were not binding. In other words, Council was not obligated to follow the recommendations that were given by the CRB, so the final decision still rested with Council. The members of the CRB are now part of the OLT, and they will review cases that deal with the Ontario Heritage Act. Next slide. Municipalities are now able to provide the documents required to be submitted under the Act electronically to the Ontario Heritage Trust. Prior to this, all documentation had to be provided in hard copy form. Next slide, please. Policies have also been enacted to help transition to the new processes. If an Act process was initiated prior to July 1st, they are still subject to the Act as it appeared prior to the amendments. However, all outstanding notices of intention to designate must be addressed before July 1st, 2022. This means that the municipality must either pass the designation bylaw or publish a notice that the NOID, the Notice of Intention to Designate, has been withdrawn. The deadline may be extended, however, if both the property owner and the municipality agree to it. The deadline is also extended when the designation was appealed. In these cases, the municipality has 1 year from the date of the tribunal report to pass the designation bylaw. In the cases where a building has been removed from a property and the designation bylaw has not yet been repealed, municipalities must follow the steps outlined in Ontario Regulation 385-21. And any cases that were before the CRB will now be heard by the OLT. Next slide, please. So what do all these changes mean to HRH? For one, our process for listing properties may need to change. As more in-depth reviews and preparation is now required in order to list a property, research will need to be conducted earlier in the process. The documents provided by the Designation Subcommittee will assist with this, and city staff plan to provide the committee with revised versions of these documents for review and comment in the upcoming months. In terms of designations, the tighter timelines for proceeding with designation may mean that more emergency HRH meetings may need to be called. Next slide, please. And there are still some things that remain unclear with these new changes. For one, the criteria for listing properties remains unclear. While ministry staff have verbally stated that municipalities should use provincial designation criteria, or Ontario Regulation 9-06, to determine whether a property is eligible to be listed on the register, this policy has not been formalized in any legislation. The new distinction made between alteration and demolition is not reflected in the current definition of alter, which may cause some confusion in how the new Act is implemented. Finally, the policies that deal with the erection or demolition of a structure in a heritage conservation district, which falls under Section 482.1 of the Act, have not yet been proclaimed, and it is unknown when they will come into effect. So this concludes the presentation on the new changes to the Ontario Heritage Act. If anybody has any questions, now's the time to ask them.
Marge, you're muted.
Marge, you're on mute.
Thank you. Sorry. Okay, Karen's has moved it. Karen, did you want to speak, talk about this presentation?
Thank you, Madam Chair. Yeah, I'll move this with thanks. Thank you very much, Pamela. That was a superb presentation, very comprehensive. Just a few things. Number one, could you please make sure that the members of committee receive copies of your presentation? I think it's very important that we have it in our back pockets. Secondly, through you, Madam Chair, to Pamela, I'm a little bit concerned about the fact that they've changed the notice of intention to designate, that now it just goes straight to council. It doesn't have to come through Heritage Richmond Hill Committee. Do you have any insight into that? That they're bypassing the committee that they, that is set up specifically for this being one of the purposes?
Yeah, through you, Madam Chair. My apologies, Councillor. It still will come to you. I didn't mention that so you're still the advisor committee. So anything to do with the Ontario Heritage Act, it still would have to come to you, and your recommendations would be brought to council.
Excellent. Thank you. I'm pleased I
good.
It's all good. Okay, good. The last thing through you, Madam Chair, if I may ask of Pamela. So just listening to this and reading this, it appears now that the Conservation Review Board is defunct. Is that correct?
Through you, Madam Chair. Yes, that's correct. It's been absorbed into the Ontario Land Tribunal. And we had a presentation done by the ministry, and I asked what happened to the board members, if they would still continue on. And ministry staff did assure me that they would continue on as part of the new tribunal, and they would be the ones responsible for any heritage-related issues going forward.
Okay, that's good. Thank you. That makes me feel a little bit better as well, because I was really concerned about that. The Conservation Review Board members are so important, and they have such specific views and intelligence on the Ontario Heritage Act that I would be very concerned if this just went to OLT as a whole. So knowing that those members would be seated if there was going to be anything discussed through the OLT with regards to conservation and heritage, I'm very pleased to know that those members would be seated. So I think that's something that we should keep an eye on and make sure that if the city has anything before the OLT, that Conservation Review Board members are seated there, because it's incredibly important. It's I know from my experience with the DDO, if it wasn't for the Conservation Review Board, we may have come out with a very different decision. So the Conservation Review Board was the first provincial body to hear the objections. So and they were quite remarkable in what they did by recommending the cultural heritage landscape to go on more than half of the property. It's very important in identifying all the heritage aspects and the buildings. So they play a very important role, and I'm pleased to see that while they may be, absorbed by OLT, they're still going to play a role. So those are my comments. Again, thank you, Pamela. Thank you, Madam Chair.
Thank you for those insights, Karen. Any other questions and comments from anyone there? Doris?
So thank you, Pamela. That was a very comprehensive presentation, and I now have a better understanding of the amendments that have been proposed by the province. Wanted to ask a question about notification. So we're talking about from June 30th of this year moving forward that there's a new notification process for properties that are being designated. And I know that in the past we had a different process in place. So what I want to make sure is that all of the properties that the municipality, the city, I should say, rather than the municipality, the city of Richmond Hill has designated, that the property owners are aware that their property has been designated as a heritage property. And I think that's important for not only property owners to know that, but I also think it's important for them to understand the changes that have been proposed and have been put into effect by the province that we are now required to comply with. So I'm wondering what we are doing about educating property owners on the new requirements so that they understand that if there's an alteration now, that's considered part of demolition, and there may be a different process for them to use than what they've used historically.
Through you, Madam Chair, that the changes won't impact the property owners. Everything is from a legislative point of view. So it'd be once we receive it, then that's when all the changes would be. They would still have to go through the heritage permit process. That would still stay the same. And whenever I receive an inquiry about any alteration or any even proposal of what they could possibly do with a designated property, I walk them through the process and advise whether it be like a minor heritage permit, a major heritage permit, a demolition. So this would just be part of my outreach on a individual basis. We haven't considered doing any outreach in terms of, oh, sorry, my son is my son is yelling at me. Now I've lost my train of thought.
We haven't considered doing any outreach. That's where you were.
Yes, yeah. We haven't considered anything at the moment because it won't impact their interaction with city staff.
Okay.
But if we continue to get maybe similar questions or a confusion as to how to proceed, then this might be something that we may consider. If you have any or any of the Heritage or HRH committee members have recommendations how to proceed, staff would love to hear them as well.
Okay, happy to. I think that there is a need to educate owners of heritage properties so that they understand before they move forward with making any changes to their property, what the new requirements are, because there are timelines, and yes, they're more in the municipality, but it may impact their planning, it may impact their plan. So I think it's important for us to do that kind of an education piece. And I do have one other question, please, Madam Chair, if that's all right.
Mhm.
Yes, the province is requiring digital records, which I think is great, because I think that if we, much like you spoke about at the last meeting, Pamela, where the team is looking at putting all of our heritage property information in digital format so that it's available to everyone, I would very much appreciate an update on that at a follow-up meeting so that we can continue moving that work forward, so that we can make sure that we can have all our records available digitally to the province, as well as to property owners or anyone else who's interested in the heritage properties.
Okay, thank you, Doris. Any other comments? Helen, are you stretching your arm? Are you ready to ask a question?
Oh, no. Well, just a comment to you, Madam Chair. I think the new changes, it seems to me more clear of some of the process, right? But a lot may not impact us. It looks like it's only for example, for designation or listed properties, only for the ones that after July 1st, 2021, correct, Pamela? Right, okay, yeah, so for that reason, I think majority of our property currently listed or designated, they are not impacted, right?
Through you, Madam Chair. So any new permit processes or permit applications for designated properties, they would be changed. They would have to go through the new act. But in terms of listed properties, if they're already on the register, then you're correct that they wouldn't really be impacted by this. We wouldn't have to notify them, and they wouldn't be able to appeal under the new act policies.
Okay, thank you.
Good point there. Okay. Jenica, were you asking a question? Comments? No? Okay. Barb.
Yeah, through the chair, I just said a comment. I just wanted to clarify under impacts to HRC. More research will be needed to be conducted earlier. Like, how do you know when to start conducting earlier? Like, is there a process that you already have in place and now you need to like get on board sooner? Like, because when you say conducted earlier, like if a property is not a problem and then it becomes a problem, when would you have known you've had to do it earlier? I don't know. It's sort of, and what sort of demand will that put on staff, and who does that research? Yeah.
Yeah, through you, Madam Chair. This is something that we still have to figure out. That last month, we reviewed a couple of documents that the designation subcommittee provided. We feel that this is a great step forward to help us do the work that needs to be done before. Because prior to these changes, we would only research a property in depth when it was considered really for designation. Many of the properties that are listed now, they were looked at preliminarily, just kind of no in-depth research. We can't confirm how much research has been done in the past. So now it's a more formalized process. We know that this type of research must be done and we must provide this information in order to proceed with the listing process. So now it's just moved up from designation potential to listing potential, if that makes sense.
I have one question. If a designated property is sold, does that impact anything? And does it, when a designated property is sold, are the restrictions, the issues with it being designated, is it mandated that be part of the sale? The new owner needs to be told what's happening?
Under the Act, we're supposed to be told when there's a new owner. That almost never happens. The designation bylaw, though, is registered on title. So as part of due diligence, the owner will find that information out. Yeah. And it's also available online before they even purchase a property. They can look it up. They can give me a call. And that's when I could advise them what the changes are, or what limitations there are to alterations, or what the process would be to making any modifications to the property.
Okay. Thank you for that. Okay. Any other questions, comments for Pamela? We can grill her a bit more if we want to. No? Okay. I've enjoyed this discussion. I think it's been very good. Certainly enjoyed your presentation, Pamela. A lot of information there. I may have to go back and revisit it, but thank you for all the work that went into that.
My pleasure.
Okay. So we've had it moved. Are we all in favor of accepting this? Okay, very good. Not any opposed? No. Okay, it is carried. So it's we're going to accept your report. So that's good. We move on. So thank you very much. Okay, next is the date of the next meeting is November the 9th at 7 o'clock. And I think we're still on Zoom by then. Okay, and so then we move to adjournment. Anyone moved? Yes, Doris, to adjourn this meeting. Okay. And all in favor? Excellent. Okay. Motion carried. We adjourn.